Counsel, are you ready to proceed?
Yes, Your Honor.
You may approach. We will allocate 15 minutes per side for this oral argument. Would you like to reserve some time for rebuttal?
I would, Your Honor, 5 minutes.
So noted, Madam Clerk. You may continue, Counsel.
Thank you. Hinda Klein, on behalf of the appellant in this matter, we have raised 3 issues on appeal. The first is that the trial court abused its discretion in denying a motion for a new trial or a directed verdict based on the improper admission into evidence of the RFA estimates, which had previously been undisclosed. Our second issue is that the trial court misapplied the law in denying our peremptory challenges as discriminatory. And the third is that the trial court abused its discretion in denying our motion for new trial or remitted as to non-economic damages because the manifest weight of the evidence shows that Connie was not permanently injured. The first issue we're raising is that the trial court clearly abused its discretion in permitting into evidence an opinion on the RFA estimate that had previously been undisclosed. As the record clearly reflects.
So the trial counsel knew that Dr. Satman was going to be recommending RFA, right?
Correct.
And Dr. Satman estimated it would cost $12,000.
She said that would be her cost, but she didn't know the entire cost of the procedure because there are other
Okay, so
portions of it.
during trial, they produced a statement saying that the RFA would be anywhere from 35 to 45.
Correct. That they had received the day before and provided to our counsel the day of the testimony. And that was a clear violation of both the discovery deadline, which was back in October of 22. This trial was January 3rd to the 5th of 23.
Why do you characterize it as an opinion? Isn't how much the procedure is going to cost a fact?
Well, it's an opinion to the extent that the plaintiff was offering it as a reasonable value, because that's, of course, what the jury is going to be asked.
Right, but how much that practice is going to charge for the procedure is not an opinion. That's a fact, right?
Yes.
And that fact wasn't proven with any other evidence in the record other than a letter manufactured by the plaintiff on the day of trial. Is that right?
Correct.
So basically a letter written on the day of trial was introduced into evidence before the jury to prove a central fact regarding the future damages.
Correct. And as I said, that was in clear violation of the court's pretrial rules, as well as, frankly, unfair surprise.
So Dr. Lowell was the defendant's expert, right?
Yes.
And Dr. Lowell owned the surgery center where the procedure was going to take place.
I don't know if he owned that particular surgery center.
No,
because
I saw something that said he was part owner of the surgery center where Dr. Satman would perform the RFA. There was something in the record to that.
No, I don't.
Okay.
I believe, and I could be wrong, but I believe he owned a surgery center.
So he would know what it would cost most of the time to get that procedure, correct?
He would, yes, he would, absolutely.
And so if the letter that was entered into evidence was way off, Dr. Lowell was in a very good position to challenge that number, correct?
Well, the problem is that because
I could see if if your side was in a situation where they presented a number and you didn't have an expert ready to testify to that, then you would be prejudiced. But you had an expert who had lots of knowledge of what this cost in the courtroom. So I'm having a hard time seeing the prejudice. That's what I'm trying to say.
A couple of things. First of all, we were given, 3 hours to provide that to Dr. Lowell and no opportunity to confer with Dr. Lowell. Second of all, we may very well, given that Dr. Lowell testified $600 to $900 versus $35,000 to $40,000. We did not have the ability at that point in time to have deposed the individual who actually put that number
But you
together.
do agree, counsel, that Dr. Lowell could have testified concerning the reasonableness of the RFA cost estimate?
Yes, he could have.
Whose burden
could.
is it to prove the amount of money that it would cost for the RFA in the first place?
It's the plaintiff's burden to prove a reasonable value, and the Dr. Satman couldn't say anything other than this was given to me just now, and I have no idea how they reached this number. And
So there's no issue concerning the admissibility of the estimate?
well, yes, because it was never disclosed before the trial at any point in time. And because Dr. Satman couldn't say how that number was reached. She'd never seen it before. She was
But
literally
your
on the
objection
stand.
was it was not disclosed, not that it was hearsay. There was no hearsay objection made.
That's correct. That is correct. But when
Again,
we,
going back to Dr. Sassman's RFA, how could the RFA cost estimate have been a surprise when the defense knew of the recommended treatment and that there would be a cost associated with that treatment?
because very clearly the plaintiff in this case didn't disclose any witness was going to testify as to future medical expenses.
Well, didn't the defense counsel know at the beginning of the trial that Appley would be seeking future medical expenses?
Not necessarily, no, because it had never been disclosed to them, never.
Is it also possible that defense counsel went into the trial thinking, wow, at least with respect to future damages, we're going to have this one made because their expert, supposedly their treating physician, was unable to specify an actual amount. So that would be a slam dunk, right?
That appears to be, what the thinking was that, well, we don't have a burden. It's the plaintiff's burden. The plaintiff has disclosed that. No witness, no evidence to establish a reasonable value for the procedure.
Was the administrator listed as a witness?
Excuse
The
me?
administrator, the
No.
one that wrote the letter, was she listed as a witness?
No, the administrator was not listed as a witness, and Dr. Satman's listing said she would testify to everything except the cost of future medical care.
Yet
So,
she got to write a letter on the day of trial, essentially to the jury,
yes,
directly telling them how much this was going to cost.
And-
Without being
and-
subject to cross-examination, without being subject to any expectation of foundation, like where that number came from.
exactly. That's exactly our complaint in this case.
Isn't that the point of discovery? I mean, isn't, like, typically when you prepare for trial, don't the parties, like, give the information, the witnesses that they're going to rely on,
Yes.
allow you a chance to depose them?
Exactly. And there was literally no excuse provided to the trial court in this case as to why this just appeared on the second day of trial. Just that, well, I just got it. And it
But,
may.
and I think the trial court got that it was a discovery violation, but I think where the trial court had a problem is where I'm having a problem. What level of prejudice attached to your client? Because there was knowledge that this RFA was going to be required. There was not testimony on how much it would cost, but you had an expert that certainly knew how much it would cost. You could have asked him. I mean,
could have
I know you
asked him
wouldn't-
had we
I know
not
you
been
didn't
in
have the
trial.
burden. You wouldn't have put him on, but you could have had an idea of what it was going to cost before you got there, right?
Well, I mean, theoretically,
Not
but
saying
again,
you. I know
were-
you didn't do the trial. but
Well,
yeah.
I don't know
Yeah.
what Dr. Lowell happened to be doing that morning. He may very well have not been, available to confer. I don't know that. It's not part of the record. We certainly were not available to confer with him because we were in trial. And honestly, given the facts behind this disclosure, it should not have been introduced into evidence given the obvious prejudice to us and why it's like the Grau versus Branham case. Everybody has a right at the beginning of trial to assume that discovery is closed.
Does your client have a constitutional right to a fair trial?
Yes, Your Honor. Yes, he did, and
Do you
this was
think
not
it's fair to have plaintiff's counsel bring to you on the second day of trial, a manufactured piece of evidence to fill in a gap that apparently was existing in their case in chief?
I do not. And as the court can see, it was fully 2/3 of the verdict.
And whenever we assess error and prejudice, isn't that essentially what we're expected to assess at the end of the day? The prejudice is, did you get a fair trial?
That's correct. And
And so is it your argument at the end of the day, so you're looking for a new trial because this trial judge first denied your client 2 peremptories based on an incorrect legal standard, and then allowed the plaintiff to prove a central part of their case through a piece of manufactured evidence that was not previously disclosed through a witness who was not previously disclosed, and let that in. And then let the expert testify to it, even though the expert, or the treating physician, it wasn't really expert testimony in that respect, testify to get that in front of the jury.
I wholeheartedly agree that really, both of those issues clearly denied us
If it's
a
okay
fair
with
trial.
my colleagues, I'd like you to talk a little bit about your Melbourne issue.
Excuse me,
If it's okay with my colleagues,
All
I
means.
would like you to go ahead and talk about the Melbourne issue.
the Melbourne issue. I'm sorry, I didn't hear, Your Honor. Well, our second point was that the trial court clearly misapplied the law in denying both of our peremptory challenges under the assumption that because those potential jurors said that they could be fair and impartial, and because these particular jurors were black, that somehow that was not a race-neutral reason that we could support peremptory challenge.
Counsel, did you renew your objection prior to the jury being sworn?
We did not, Your Honor. But
Does that present a problem for you?
it's a potential problem for us, but as we pointed out in our brief, we freely admitted that we did not renew that objection. But we also noted that the jury was sworn literally minutes later. And as the court can see from the court's response to the voir dire, it was quite definitive. The court was clearly not going to reconsider anything. She repeatedly said,
But I mean, we have lots of cases where it's clear that the trial judge has made up their own mind, and I know that you're supposed to present it to them again so they can change their mind. But we have plenty of cases where it's clear that the trial judge is not going to change their mind, but we find it not preserved if they don't, before the jury is sworn, they don't renew all their objections.
well, that's true, but I mean, in a number of those cases, unlike in this case, it wasn't something that occurred almost immediately thereafter, such that there was no reason that we would believe that the court would change its mind. And there have been numerous cases, especially out of this court, finding that where it's obvious from the record that further objection would be useless, the court has, in fact, found that it's been sufficiently preserved to at least be considered. And under the circumstances...
You've probably seen a few trials in your career. So during jury selection, what is the typical terminology? So if you're not going to exercise a strike, what is the terminology that is used? Isn't it accept? We accept the panel? Isn't that typically what is said?
Yes.
What would be an alternative? What is something else that the defense counsel could have said in those circumstances? He's attempted to exercise peremptories. They've gone through this whole thing about the challenges, the Neal challenges, or whatever you want to call it, pushed back on the judge, pulled the Princess Bride kind of thing where I don't think racial neutral means what you think it means kind of thing. And then at the end of the day, so then they have to exercise peremptories or not, and he says accept, which is the typical terminology. Is there something else that a counsel is supposed to say in those situations?
I mean, I've seen various things, except with the, reiterating our objection, but I think...
That I just made like 2 minutes ago?
Yes, exactly. I mean, it's
Counsel,
form
regarding-
over substance.
Regarding the case law, do you agree that you have to renew your objection prior to the jury being sworn?
That is what the case law says.
Going back to the prejudice prong regarding the admission of the RFA cost estimate, do you agree that your expert, Dr. Lowell, could have opined about the reasonableness of the RFA cost estimate?
I would agree that he had the background and ability to do so. I would disagree that this record shows that he had the opportunity to have found that out for himself. I'm sure it's not off the top of his head. And I also would point out that there's nothing in this record that shows that we had the ability to confer with him. So saying that Dr. Lowell, who's going to testify in 3 hours, can respond to that is, on this record, it's basically saying, well, he's there, but, it's your problem to find him, to confer with him, to hope he's not in with a patient. And we shouldn't, frankly, have been in that position in the first place.
Assume, for the sake of argument, that we agree with you that the trial court should have excluded the cost estimate. Is the proper remedy to reverse in part and remand for a retrial on damages or future medical expenses only?
I think just future medical expenses under the circumstances, and there is, and I saw it this morning, and I'm not sure if I can find it right now, but there was a recent case talking about how that's handled on remand, and there are two options for the trial court in that situation. The first is to say, okay, we can have a retrial, but you're stuck with the evidence that you had before the trial, or after an inquiry as to whether or not the opposing party acted in bad faith in withholding this evidence, then the court can find, if there is no bad faith, that maybe discovery has been reopened. But yes, I agree with the court that the appropriate thing would be to remand for a trial on future medical expenses.
Well, on the directed verdict question, though, considering, so the statement about the letter, the manufactured evidence, if that is not, so the question is was there competent substantial evidence or evidence from which the juror reasonably could conclude a fact? If that evidence was not competent, which doesn't strike me as being, however, it wasn't specifically raised as a competency issue, can we still consider whether the judge erred in not granting a directed verdict if we look at the evidence and conclude that it wasn't competent evidence? Does that make any, do you understand what I'm?
Yes, and we did raise that in our argument on directed verdict, that the court should basically have found that the evidence was inadmissible under the circumstances, and therefore there was no other testimony regarding future medicals, and we were entitled to a directed verdict on that.
Even if the objection had not been raised in that way, just as it's like this was unfair, it was ambush, but they don't address specifically the fact that it's hearsay, double hearsay, lack of foundation, all this kind of stuff. We can still look at that from a directed verdict analysis and reach our own conclusion and say, yeah, that wasn't competent evidence to support the verdict, and still grant you relief on that front?
Yes, Your Honor.
And what would that look like? Would it be just a remand with an instruction to strike that amount?
Yes, I know that there's a case, and I apologize, I'm
just trying to figure out
out
which relief you're looking. Would you rather have a new trial on everything, on some of it, or just striking of that amount from the?
I think we would like a new trial. I mean, I think we would like a directed verdict on future medical expenses, given how much of this verdict that was.
Would you agree that the jury was presented with conflicting testimony about whether appellee suffered a permanent injury in the subject accident?
I think on a review of the record, I think there was probably enough to survive a directed verdict on permanency. But I do believe that Dr. Satman's testimony that basically she hadn't reviewed the prior medical records, and she basically had been told by the plaintiff in this case that she had no prior history of neck and back when that was not in fact the case. I think that certainly the manifest weight of the evidence would warrant a new trial on that ground as well.
And assuming that's the case, like assume that there's enough that she suffered a permanent injury, and then it's a question of, well, was there enough to support, future medical, future damages? Now, it doesn't have to be precise. The evidence doesn't have to be precise, but
Correct.
does there need to be, how much does there need to be to, I'm assuming we don't expect our juries to guess at a number. I mean, that would be arbitrary. We expect them to look at the evidence. So how much do you think is enough? And does there need to be a number at all
For
for like the damages? So they take away the letter. So you basically subtract out an actual, any evidence specifically about a number on that. Could there still be, just in the sake of reasonableness, can there just kind of be this miasma or this general idea of what, a range, or how specific does the evidence need to be?
Well, there has to be something on which a jury could estimate those future damages to be. Clearly, it doesn't have to be accurate to the penny, but jurors are lay people. They have no idea what, medical care costs in the future. And without Dr. Satman's repeating the 35 to 45, you literally have nothing, because I believe, Judge Roberts, the $12,000 was what she said during her deposition, but she testified live. So there literally would have been no guidance given to the jury on that issue. If the court has no...
Before you sit down, counsel, you do agree that when you make an objection at trial, your objection has to be specific.
Yes.
If you object based on the question being irrelevant, but the basis for sustaining your objection is that it's hearsay rather than relevancy, then have you perfected your objection for purposes of appeal in terms of hearsay?
Not according to the case law, Your Honor, no. But again, our objection was primarily that it shouldn't have been admitted because it was never disclosed. So if the court has no further questions, I guess I'm into my rebuttal. So I appreciate the court's consideration.
Counsel, in view of the questions, appellant did exceed her time, so we will extend your time by an additional 5 minutes,
Thank you, Your Honor.
if needed.
Thank you, Your Honors. May it please the court, Michael Korn of Jacksonville, here for the appellee. Let me address a couple of the record issues that Judge Roberts' questions were addressed to counsel. First, Dr. Lowell was, in fact, the record established in numerous places. He was a partial owner of the Ocala Surgery Center where these very procedures were to be taking place. Secondly, he performs radio frequency ablation, RFA procedures himself. He testified that he doesn't like them, he doesn't think they're useful, but he certainly does them in certain instances. And finally, as to the question about disclosures, I would note, first of all, that there was a stipulation in the pretrial stip that the records custodians were not going to be necessary. However, at page 92 of the record...
But that was based on the exhibits that had already been produced.
Sure. Well, that was, this was filed back in...
When you agree that they're not going to have to authenticate, that doesn't mean you can show up during trial with something new.
Understood. I'm just, we're saying we had no idea that records custodians could be in play. They certainly had been disclosed back in November of 2022.
Why does that matter in this context? This letter was not a business record in any way, shape, or form. So, even if you didn't stipulate to the authenticity of business records, obviously you did, that doesn't apply to this letter, even if it had been disclosed months earlier.
But the bottom line, Judge, and I understand the court's questions, The Binger analysis and the cases that are legion that follow Binger talk about it's not just surprise, it is prejudicial surprise. And this goes back to when Dr. Sapman was deposed about 3 weeks before the trial, mid-December 2022. And as Judge Roberts pointed out in his questions to counsel, she said, I don't have the precise amount of each component. That was the facility fee. That's the facility fee that would go, at least in part, to Dr. Lowell. The anesthesia fee, the supplies, the prep, and the professional fee. And she estimated that the professional fee was $12,000 per procedure. She recommended 5 RFA procedures for the plaintiff, given her determination of permanency as to both her neck pain and her back pain, which she opined was permanent as to an aggravation of a pre-existing condition. So if we look at the real-world impact of this, first, the defense is required under the Donis case, and these are all cited in our brief. The Donis case says that the plaintiff that the party who is objecting under the Binger grounds must show substantial prejudice. And here, it was not substantial prejudice. They knew that there is an amount. This witness, Dr. Lowell, who did the CME and is apparently does about 2 or 3 a week exclusively for defense, was very familiar with not only the procedure in general, because he performs them, but very familiar with the procedure at his own center. So what did the judge say when this came up in the morning of trial? And which I think was sufficient under the Suarez-Burgos case, again cited in our brief, said if something comes up during trial, counsel should immediately let the other side know. What did the court analyze in exercising discretion on this point? She says, Dr. Lowell is well known to the court. He's what we sometimes refer to as a professional witness, and he acknowledged that he does 100% defense CMEs. And it will take Dr. Lowell all of 5 minutes to opine as to whether this cost amount is in bounds or out of bounds. This was not.
Why is it their burden to establish that number in the first place? Obviously, plaintiff's counsel thought there was a problem. Why submit the letter at all? Why not just rely on?
And if the letter hadn't, let's just hypothetically say the letter had not been submitted, then the colloquy during trial, when Dr. Sapman actually testifies before the jury, would have gone back to you said $12,000 per procedure times 5. We know that the facility cost, that's just to the surgery center, is something a little south of $1,000. And we know that there are other estimates. And the case law, and we cite in our brief, says that the estimate of future meds need not be proven with exactitude. One of the reasons the defense alleged that, she may not come back for the 5 RFAs, so why should we give them these damages? Well, that's, somebody could fall off a bridge and not use it. It doesn't mean they're not entitled to the damages. The bottom line here was that the trial judge was presented with the situation. She specifically addressed it. She specifically asked the defense, how are you prejudiced? And then the answer was simply, well, we were ambushed. She asked, how were you prejudiced? Because your witness, who's no newcomer to this process, could very well have determined that amount is way out of bounds or that amount is within line with what I would charge if I was performing an RFA at the same center. So under those
But you went through the first day of trial without a critical piece of evidence. And so I can't think of a better definition of ambush than coming in on the second day of trial and saying, oh, by the way, we just had someone write a letter to prove our case on future damage.
Judge, the idea that defense was kind of like the line out of Casablanca, that he was shocked to find out that that because a permanent injury was occurred, we were going to be seeking future meds.
It's not a question of whether you're going to seek future meds. It's a question of whether you're going to be able to prove it.
Well, they could have.
And apparently you weren't going to be able to prove it, and that's why the counsel wrote the letter.
Well, I respectfully, Judge, I disagree, because I think that they could have, if the letter had not come in, the testimony could have come through just as it did when Dr. Sapman was testifying 3 weeks earlier.
The doctor was guessing and made it clear in the deposition that they had really not a great idea of what it was, because they don't run the center, don't own the center. It was just guessing, and that would have been a far different testimony than having a letter come in from the administrator without any foundation, and just improve that number, and then just filter it through the expert.
Well,
That sounds like a big difference in
it's,
improve.
again, and the case law says can't just be adverse testimony, it's got to be surprise testimony, and I would respectfully suggest that the court, in the middle of the trial, could very easily make the proper determination that this was no big surprise, that the permanent injuries were being alleged, and that as a result of those, future medical treatment was going to be necessary. And frankly, the amount was
Could this
conservative
cost
in nature.
estimate-
Yes, sir.
Could this cost estimate be considered a new opinion?
No, it is not, and that's why it doesn't really trigger the entire Binger analysis. It's not a new opinion. It is simply a determination of what exactly was the amount that would be necessary to make this plaintiff whole. And there was testimony in the record already from her deposition that would have allowed it if the court had gone the other way. So, and again, I would suggest that the reason you don't see any testimony directed to Dr. Lowell by the defense about the RFA costs is because they took a position, perfectly legitimate trial tactical position, that we were admitting nothing. They didn't admit that they were liable on a rear-end collision where the plaintiff was stopped for 5 seconds. They didn't admit that there was any permanency. At most, they admitted that, well, maybe we'll give her $12,000 in past meds. So would we necessarily be surprised at the fact that they would take the position that, oh, well, let's roll the dice, not ask Lowell anything, even though he knows it, because we're gonna take the position that maybe we'll roll on liability, that maybe somehow the jury will buy our denial of liability, claiming that the plaintiff's vehicle was somehow rolling when she was struck from behind, which was negated by the third-party eyewitness.
Getting back to the RFA cost estimate, why did the appellee wait until the second day of trial to produce the cost estimate?
The record doesn't reflect it, Judge, and we can only speculate as to why. So I can't. I could give you 3 or 4 possible reasons from a trial tactics standpoint why. I can't, from this record, tell you anything. The lawyer said, well, this is the reason why, or this wasn't the reason why.
Well, then, do you agree that the appellee violated the order scheduling pretrial conference and jury trial by failing to file and serve the cost estimate letter at least 30 days prior to the pretrial conference?
I'm sorry, Judge. I'm not sure I totally understood your question.
Again, with that said now, do you agree that the appellee violated the judge's order scheduling pretrial conference and jury trial by failing to file and serve the cost estimate letter at least 30 days prior to the pretrial conference?
That happened, but that's not fatal to what happened at trial. As an example, the case was set for trial the week of January the 3rd, and Dr. Sapman was not deposed by the defense until, I want to say, December the 14th. So this wasn't like a situation where all of the evidence was in place and ready to go, and we just have this, this one issue. So this is precisely why the case law under Binger has developed, Judge, is precisely to evaluate how does the trial court exercise its discretion in determining whether there has in fact been material prejudice to the party complaining of the violation.
But your point that it should have come as no surprise to the defense that you're going to be seeking future damages and that there's going to be some sort of cost associated with the RFA, doesn't it go both ways? Because didn't your client know, or shouldn't the plaintiff have known in advance that they're going to have to prove an amount, and after that deposition they had 2 weeks to prepare, that maybe contact the administrator, or maybe list that administrator as a last-minute witness, doing something to prove that case in the first instance?
Your Honor is asking me again to engage in some measure of speculation as to what was in everybody's heads.
Well, you've already done it for the other side, so why not do it for your side?
Well, I can't. I'm not speculating about what the other side knew, because
we
know what the other side knew. He's their witness. He's testified for that firm before. It's not apples and apples, respectfully, Judge. I don't believe that to be the case. In a perfect world, everybody is going to, have a I guess now we're going to be going into our perfect world pretty soon with the new Supreme Court guidelines on case management. And so maybe we'll be more like the federal court and things are going to be running like that. But right now, this is the trial we had. And ultimately, Your Honor asked counsel, was it fair to the defendant? And I would submit it was. That there was no violation of due process. The defense took a maximalist view. We're going to go for it. We're not going to admit liability. We're not going to admit permanency. We're not going to admit anything. And that's fine. That's a legitimate trial tactic, but you bear the risk, and the risk was what happened here. I would like, if I might, to switch gears for a moment and talk about the Melbourne issue.
So the trial judge, with regard to the Melbourne, she says, I'm not hearing anything that tells this court or anybody else here that he has an inability to be fair and impartial in the case. So it's unclear to the court that the reason you are striking him is merely because he's black. So I've given you an opportunity to give me some reason why you are striking him, and the reasons you have given me are not tantamount to him being stricken as a prospective juror. I read that and I see not only an incorrect usage of not even using the Melbourne standard, it looks like a for-cause standard, but also they shifted the burden from the objecting party to the party that was making the strike, which is not allowed by Melbourne.
The case law tells us that this step 1, step 2, step 3 analysis that Melbourne discusses.
Yeah, that didn't happen.
But it is not necessarily required in each case. It's not like a tennis match where in order to score a point, you must hit the ball over the net. Sometimes when the opponent hits the ball into the net, as we suggest was done in this amalgam step 2, step 3, that the procedure that the trial court did was appropriate.
So the objecting party has to point out that the juror being strike is a member of an identifiable race or sex group, right?
Did that, yes.
And then the next step is the judge is supposed to ask the person using the peremptory what was the non-racial or non-sexual reason why you made this peremptory challenge, correct?
That was done, yes.
Okay, and they said that. And then the judge failed to evaluate the genuineness, and it's the genuineness so that Melbourne says genuineness, right?
Yes, sir.
So the judge seemed to not do that.
Well, the question, though,
And
is...
then applied a for-cause standard.
But the question is, would it have been any different or any more permissible, or better, if you will, for the court then to turn to plaintiff's counsel and say, counsel, can you address what the defense just said? And I'm guessing, again, speculating, but I'm putting a reasonable guess that the plaintiff's counsel would have stood up and said, that's not a basis. It's evident that the ostensible answer that the first juror gave, that there was eliciting something about his definition of brutal truth or honest, brutal honesty about the case, and he referred to his mother. And so he said, that is obviously, a pretext.
Will you agree that a person can exercise a peremptory challenge for any reason under the sun?
Absolutely.
I don't like his suit, I don't like his hat, I don't like his glasses, as long as it's not for a racial reason.
Well, or for some other protected class, not necessarily racial, it could be female.
Or sex.
Yes. But in this case, I mean, we'll come back to what I believe is really the gatekeeper part of it, which is the waiver issue. And Judge Lewis addressed that in questions earlier.
Before you address the waiver issue, counsel, do you agree that appellant's explanations for his peremptory challenges were race neutral on his face?
They, based on some of the case law that has been dealing with this, you could argue that was the case. But as I was trying to address with Judge Roberts,
if
the
your
court...
question is no, then why?
Excuse me?
If your answer to the question is no, then why, without addressing the genuineness of the question?
Well, the court was able to basically, in the colloquy, and Judge Roberts read it, it's in the briefs, this was not a basis for finding that the juror could not give a fair and impartial hearing to both parties.
That's not how peremptories work. It didn't matter. That's not the inquiry, whether it's fair and impartial for a peremptory. You can use them for any reason, as long as it's not a racial reason.
Except for a pretext. And here, The
Well,
pretext
the
was...
judge is required to determine whether the reason you gave was genuine, and the judge didn't do that.
Well, again, the Step 3 analysis, and the case law tells us this, the Step 3 analysis can be implicit. It doesn't have to be an explicit statement on the record. That case law is set forth in the briefs. And
But the judge cannot recite the wrong standard, then apply that, though.
in a perfect world, the colloquy might have gone differently, but at the end of the process, the backstrike attempts to exercise the 2 peremptories on 2 African-American males for an African-American plaintiff was, in our view, appropriate. And in any event, even if any of that was flawed in any respect, they still did not renew the objection. They accepted the jury. And what could they have said in response to a question previously asked? What could they have said? Your Honor, sidebar. So I wouldn't want to put it in front of, with Van Irie sitting there. You say, Judge, for the same reasons, we want to, renew our objection. And the case law tells us that the reason why that renewal is so important is it's the final opportunity, either A, for the party seeking to exercise the peremptory to convince the court of the correctness of their position, or to convince the court that their initial assessment was incorrect.
Sure. I mean, and we've talked at some length that, that we all know that you have to renew your objections to, any objections you made before the jury's sworn. We all know that. But tell me why we shouldn't be guided by State versus Smith. That's the 2014 case where we said that if the jury is sworn only a matter of minutes after the objection, it's not necessary. So talk about Smith and tell us why we shouldn't apply that.
Under these circumstances, especially given the colloquy that Your Honor has already identified, I think it would have been prudent, if not required, for the defense to and I would do it at sidebar, and to say, Judge, we are renewing our objection. If the court then says, I've already ruled, then the jury is impaneled and sworn.
And you've done what you need to do there.
And they've done what they've done. Yes. Preservation is preservation.
If the purpose of preservation, if you think of it more practically, if the idea of preservation is so the trial judge, if they get an opinion back from this court and says, hey, you messed up, we're reversing, the idea of preservation so the trial judge doesn't feel sandbagged by it. It's like, well, where did that come from? Like, I didn't know that was still an objection. Do you think on this record the trial judge would be surprised if she received an adverse ruling saying, based on the peremptories? Or do you think that she legitimately thought, well, gosh, I know that we spent like 15 minutes going back and forth on these objections and my defining what race neutral means. I thought they were good with this jury after all.
Well, they finally acquiesced. Lots of times you object during jury selection, but in the end you're like, this is as good a jury as we're going to get. Let's go with it.
And that, Judge, is precisely why the renewal has to be made, and that's what the case law says. It says, we have to assume that at the end of the day, here's what we're looking at in the box, and maybe I'm good with it. I'm going to roll with what I've got, and that's why you got to preserve it. That's why the preservation is so important, and that's why we really don't, have to worry about, respectfully, Judge Tannenbaum, what the trial judge might be thinking about whether the colloquy was correct, sufficient, or incorrect. My extra time has now expired.
Can I just ask on the directed verdict front, take away the letter for a moment. What other piece of evidence supports the number for future damages?
Well, again, if the letter had not been admitted, there would have been a different manner.
Not would have been. On this record, take away the letter. What other evidence might be construed that you think is competent, substantial evidence to support the number that the jury came back with?
Well, at minimum, the amount that Dr. Lowell testified about, which is the only number that the defense asked him about, which was the facility charge, which was $900 and $600, depending on certain procedural differences.
Any other evidence?
Not that comes to mind, but again, it would have been handled differently had there been a different ruling, for sure.
Dr. Satterman's testimony, the opposition testimony concerning the reasons of the physician component of the RFA was $12,000. Was that also part of the trial as well?
I don't believe that was published. I don't believe that that part of the deposition was published. And my extra time has now expired, and I thank the court for your very penetrating questions and ask that you affirm.
Thank you, Counsel. Counsel, you've used up all of your time, but we will allow you 2 minutes to wrap up.
Thank you, Your Honor. I just wanted to make a couple of points. With respect to the admission of the new quote-unquote evidence, I wanted to point out and emphasize that Dr. Satman had been listed as a treating physician who was going to testify on injuries, treatment, causation, and permanency. No mention of cost. In the pretrial statement, where the plaintiff was required to itemize special damages, the plaintiff itemized no special damages. With respect to the issue of whether or not the costs was a surprise, if the court looks at pages 887 to 892 of the record, you'll see that the trial court repeatedly stated that this was not a surprise at all to the defense, because we knew that there were going to be, or arguably there was evidence of that she needed 5 RFAs. The court simply did not give any credence to the argument that the reasonable cost of those RFAs was a significant part of the plaintiff's burden of proof. And that, I think, is precisely why the trial court erred in letting that information in. She simply didn't understand the significance of it and the significance of the absence of it, which, and we've pointed this out in our brief, is evident from the Volusia versus Joint case out of the 5th District 2015 and Lofton versus Wilson. One must demonstrate, the plaintiff must demonstrate, not only the likelihood that there would be future treatment, but also the reasonable cost of that future treatment. That is a key element of the plaintiff's burden of proof, and without that, we would have been entitled to a directed verdict on that portion of the verdict, which wound up being 2/3 of the verdict. So this was clearly a substantial and prejudicial error. And other than that, I wish to thank the court for your consideration. Thank you very much.
And thank both of you, counsel, for your respective oral arguments this afternoon. This concludes our oral arguments for this afternoon. We are adjourned.
All rise.